So part two of our guest speaker here.
Oh, it's along the line. Okay.
Sorry we had to break. For those who are a little late,
Yeah.
we did have we do have another class. They're incoming. For those who don't know, so really, you know, a treat like this, I don't want to just keep it just the art class.
You want to wait for them to come in, or you want to go right now, or?
Oh, is someone else?
No, you said another class coming.
Oh no, yeah, they they left. I'm gonna let Mr. Deskovic continue. One thing I want to highlight that he said before, you know, the withholding of papers. That was what the prosecutor spoke to you about. I think Brady evidence at 100 documents. You know, at Brady evidence, you know, material that would have been favorable to the defense and would have made a difference. The Supreme Court has recently decided on this issue. Some would say not so favorably. With that, let's start part two of Mr. Deskovic's lecture. Thank you, Jeff.
Thank you. So, jumping on Brady here for a second, some of the most common type of Brady violations when deals are given to informants in exchange for testimony, and then the informant lies about it, and the prosecutor swears to it, and they withhold the document. That's really a pretty common form of withholding exculpatory evidence. Incentivized witnessing, which is when someone receives a benefit in exchange for testimony. That's been a cause of wrongful convictions in 15% of the DNA proven wrongful convictions. In terms of the systemic deficiencies that lead to wrongful convictions, coerced false confessions have been the cause of wrongful convictions in 25% of DNA proven wrongful convictions. The reforms that would really address that would be videotaping interrogations from beginning to end, which would prevent the police from withholding details. It would eliminate some of the more abusive practices, and it would be clear whether or not a suspect was really volunteering non-public facts, or whether or not they were given information either directly or indirectly. But that's not the whole picture. We need false confession experts. The experts don't give an opinion on a particular confession and issue, but instead they discuss what the factors are that have been proven to lead to an innocent person to confess, because that idea is contrary to the experience of jurors. And then a new reform that's been advocated for a few years now by me, but as also other false confession experts have started to champion, would be a pre-trial hearing on the issue of whether a confession is accurate or not. So right now we just have the Huntley hearing, where we're volunteering, this is that issue, but this would be like a confessional version of like a Wade hearing, which is its counterpart in identification. So a judge could compare the facts in a confession and compare that to known red flags that have, in patterns that have, cases that have involved false confessions that have ultimately culminated into a DNA exoneration many years later. Misidentification is the leading cause of wrongful conviction, at least in terms of the DNA proven wrongful convictions. That's been the cause in 75% of the DNA proven wrongful convictions. So the reforms here would involve implementing these best practices. So sequential lineups of photo arrays, meaning one person shown at a time, so that a witness could rule somebody in or out based on a memory, rather than simultaneous, where there's just a comparison of who looks the closest. Making sure that everybody in the lineup or photo array resembles the description given by the witness, so that nobody sticks out. Videotaping the process, so that again we're not relying only on testimony. That it makes for better record and better cross-examination. Telling the witness that the actual perpetrator may not necessarily be in the lineup or photo array, so that undue confidence isn't placed. Telling the witness or victim that the investigation will continue if an identification is not made, so that nobody feels pressed into making an identification. Collecting a confidence statement would be a sixth factor. On a scale of 1 to 10, how confident are you of your identification? So that's really important, because by the time a trial rolls around, the witness will have been over it a couple of times with the police, that have testified it at least 2 pre-trial hearings, at a minimum the grand jury and then a late hearing, and the prep that goes with all of that as well. So by the time a trial rolls around, a witness's confidence would have been artificially bolstered by then, by repetition. So collecting that early information is really important. And then lastly, there should not be a congratulatory statement. So law enforcement should not say, well, great, that's what we thought that it was the whole time. Because obviously that's going to be another confidence building, bolstering factor. The double blind method. So the officer doing the photo array or lineup should not know who is actually suspected, so that there isn't any inadvertent or deliberate cues or clues given. Prosecutorial misconduct is a major cause of wrongful conviction. In fact, that's a commonality that runs through almost every wrongful conviction. Some of that obviously involves Brady. We talked about that. Also, improper arguments to jurors, including fanning passions and emotion rather than arguing facts. Threatening witnesses and in terms of this, kind of like ties back with incentivized witnessing. It's not just the benefit, either financial or having charges dropped or getting a lesser prison sentence, but then also, I mean, some people have gotten like housing, witness protection, so now you got housing and you have jobs involved. And sometimes people are threatened, parents are often threatened with removing kids from the household, so that's a lever that's pulled sometimes as well. I advocate for the Commission on Prosecutor Conduct, just the oversight board for the prosecutors. I mean, as the first step. You know, certainly not the whole picture. I'm in favor of removing prosecutorial immunity, which is a bizarre doctrine that says that no matter how egregious the misconduct is by a prosecutor, if it takes place after an arrest has been made, then they're deemed to have done so as an advocate, and therefore they have immunity. I'm also in favor of criminalization of clear-cut intentional misconduct. To me, when a prosecutor works hand in glove with experts, tell me what you want to prove and I'll prove it, or withholds exculpatory evidence, or suborns perjury, or doesn't correct perjured testimony, and that results in a conviction of somebody who's innocent, then, you know, I consider that they've in effect pulled off like a type of legal kidnapping under color of law, and I feel strongly that that should be criminalized the same way as when a civilian commits a murder. You don't just face criminal charges, but theoretically you could be sued for a wrongful death also. So on a similar analogy, I'm in favor of criminalization. Bad lawyering is another major factor of wrongful conviction. So I advocate for one statewide system so that there can be oversight instead of each county figuring it out. While the overall system is bad, as I'm going to lay out, yet when you have it done by the county, it's even worse when you get into the more rural counties because there's even less resources available. So without having one system which would allow easier oversight, so an attorney who renders deficient representation outside the realm of what you would expect from a professional, they remain in place to do so again. I believe that there should be an even financial and manpower playing field between the district attorney's office and the public defender's office. If you don't maintain that parity, then it's the district attorney can overwhelm the public defender. Certainly a limitation of caseload is important. It's not unusual for one public defender to represent 100 people at the same time. So to give some context, as students, imagine if you had to carry 10 or 12 courses at once. I believe strongly in equal pay for both sides, so the best legal talent doesn't go to one side or in private practice. And I think that it sends the wrong message, like somehow the prosecutor is doing a more important role than the public defender. I think that they're both essential, and neither is better than the other. So it should be equal pay for both sides. We need to have a standardized evidence preservation system. So if you're lucky enough to have been wrongfully convicted in the case where DNA testing is available, which is only 5 to 12%. The first hoop is whether the evidence has been lost or destroyed. If either of those things have happened, you just would be out of luck, unable to prove your innocence. And no, in case you're wondering, that the evidence being thrown out or destroyed would not be a ground for a conviction to be overturned. So changing gears, let's talk a little bit about false confessions and interrogations. So there's two types of false confessions. There's the coerced compliant false confession, when somebody is aware that they're giving a false confession, but they've been coerced to comply. And then there's the internalized false confession, which is where the defendant, the suspect, momentarily doubts their own innocence. So that happened in the Marty Tankleff case of Long Island notoriety, where he momentarily doubted his innocence, then recanted, but it was too late. Some of the police techniques that have led to that, we talked a little bit before about Mutt and Jeff, the good cop, bad cop. There's the alternative question, which is all part of the Reid. The leading interrogation technique is called the Reid technique, and that has a high correlation between that, employing that and false confessions. It's a system of questioning which is designed to psychologically coerce people. So some of the tactics, taking innocence off the table. So not even allowing somebody to issue a declaration. Look, stop. Don't say, look, I already know that you could, don't even say it, okay? Don't insult me, okay, by saying that you're in it, okay? We both know what, listen, here's my question again. See, taking innocence off the table, okay? Putting a suspect, removing them, that's the whole purpose of in the police station. Get them out from a familiar environment. Put them someplace where they're cut off from moral support, outside contact. The alternative question, do you still beat your wife? What's the good answer to that? No, I don't. So in other words, you used to. Or I still do, which is even worse. Another part of the Reid technique is, so they consider the first part of the interaction. They call that an interview, and then they separate interview and interrogation. Right? The interview supposedly is this really benign, friendly conversation, and only if they become convinced that someone is lying might they then switch to interrogation. But when studies have been done, it's really not any more accurate than flipping a coin, but yet may law enforcement feel confident. In fact, a political satire type of article was once called, I'd know a false confession if I saw one. So that's how much confidence comes to be placed. A really important tactic in terms of fighting a false confession or determining whether one is or not, it was an FBI technique. Now, I can't speak to how often it's actually employed, but I do know the technique exists, which is that they're supposed to go out and prove independently each statement in the confession. Okay, but that rarely happens on a state level, so that's another way of guarding against it. I mean, knowing what the red flags are around a false confession. If it's a co-defendant situation, then if the co-defendants give two different stories, then that's one of the red flags. If an officer asks a lot of yes/no questions rather than open-ended questions, then that's a red flag. If a question incorporates an item that a suspect then regurgitates, into a statement, then that's definitely a red flag. If a confession is contrary to other known facts, that's another red flag. So I'll give an illustration. So I remember there was one case where the suspect said that he broke in the side door of the house, but there was no side door. He said he kicked the dog to death, except that a veterinarian said the dog died by dehydration. He said he left a bloody knife in the sink, but the knife in the sink had no blood on it. He said he took his girlfriend to an abortion clinic after that, but that happened a decade before the crime. And the suspect claimed that he abandoned a vehicle on the roadside in Delaware, except that that was never found. There was no report on that. So that's an example of running contrary. certainly the police volunteering in Long Island, in Nassau. So in the John Colgate case, where it was Colgate, House, and Receiver, all wrongfully convicted based on a coerced false confession that of rape and murder of a girl who were ultimately exonerated through DNA testing. In the Colgate case, so they stopped him 5 times. So he's given his statement, he's given his confession, right, after he'd been there for like 21 hours. Right, and every time he got a detail, they stopped him, corrected him, let's take it again from the top. Okay, that happened 5 times before the 6th version was finally accepted. Okay, so when they get details wrong and correct, if a confession contains language that's way above the formal education and life experience of a defendant, then that would be another red flag. So if you get a chance to see Murder on a Sunday Afternoon, I'm recommending it. That's a great illustration of that. I mean, all these pages and pages of sophisticated language, you know, and it's a youth that supposedly is making all of this. If something is written out by law enforcement rather than a suspect, then that would be a red flag as well. So I think that there should be a lot of open-ended questions, you know, that are given. We talked about the other stuff, so I'm not going to reiterate. I mean, having a working knowledge of false confessions is important. I think that interrogation should be reviewed by a superior officer, and then, maybe even the police chief or a captain. And I also advocate for like a step-back approach by the prosecutor rather than just going ahead and prosecuting. In terms of red flags around identification, there's been significant height, weight discrepancies. So in the William Lopez case, friend did 23.5 years. So the original 911 caller got the ethnicity wrong. They said it was like, you know, dark-skinned Panamanians, and he's obviously a light-skinned Puerto Rican. And they described perpetrator 6'2", 6'3", and he's 5'7". So getting ethnicity and getting height and 100 pounds more. So height, weight, and ethnicity, you know, among some. Definitely the show up, which is when somebody is in handcuffs or in the police car and they bring them to a witness. I mean, that's very, very suggestive. That should be totally abandoned, although it's not. So those are red flags. In terms of informants, real quick, red flags that informant may be lying. See, firstly, if there is no other piece of external corroborative evidence, it's only the informant's story, that would be a red flag. If the informant's story keeps evolving or changing, just in the details, that's definitely a red flag. At times, police have asked informants to bring them to other evidence, bring us to the body, bring us to where the gun is, where his clothes are, any type of evidence, and informants have brought the law enforcement to the wrong location. So when that happens, that's obviously lots of red flags, as is a red flag if a benefit was given and then lied about it. Changing gears, discussing the criminal mind a little bit, inmate education. So prisoner education, same thing really. So I benefited. I believe in prisoner education. I benefited from it. I got the associates while I was incarcerated, and I got another year of schooling towards the bachelor's before the funding was cut by then Governor Pataki and Senator Helms on the federal level. And so the recidivism rate is much lower when a prisoner has a college education. The real reasons are fairly clear. You're equipping people for gainful employment as well as broadening horizons. I had that much less ground to cover once I was released instead of starting from scratch. So I definitely believe that any serious discussion of crime prevention of necessity must include prisoner education, or else it's just not serious. I mean, the recidivism rate's like 50 and 60%, and so low before. The pushback arguments were, well, why should the prisoners get a free education and my son, my daughter can't, or I can't go, I can't afford for them to go. But that's a fallacious argument because, first of all, the financial aid forms were the same. So nobody would be eligible to go on a grant by virtue of their being incarcerated who otherwise would not have been eligible. So that's the first thing. And the second thing is that nationally, there was half of 1% of the total student population were prisoners. So it's not like for every prisoner going to school, there was a corresponding person who was law-abiding and was free, who couldn't go because of that. So nobody's seat was taken. And just thinking about this kind of simply, I mean, who do you want to live next door to you? The person who's equipped to get a job, or you want somebody with no skills, no education, who's likely going to return back to their old ways? And who do you feel safer living next to you? In terms of alternatives to incarceration, I believe a lot in community service. I think that drug usage, not selling, but drug usage should be considered to be a public health problem, and so definitely rehabs and maybe some community service in terms of that. There's home arrest and the ankle bracelets, which can be employed as well. I think that fines have been abusive, so I'm not really in favor of those too much. I think another thing in terms of just switching gears actually to crime deterrence. We talked about prisoner education, but I think that also extends to vocational trades. So I completed a lot of trades while I was in prison. I got 6 certificates in plumbing and painting and general business and computer repair and food service and a lot of other things. So I oriented everything I did to some sort of potential usage on the street if I was fortunate enough to get out. But the problem, though, is that most of the curriculum was obsolete by the time I got in there. So I finished the plumbing program, but I got 6 certificates in it. But almost all the training was it pertained to iron pipe. And think about your apartment or your house, it's all PVC or copper pipe. So if I was to decide I wanted to embark on a career in plumbing, I would start at the exact same position as some other novice who had no experience at all. So total waste of time. So I think bringing the curriculum up to speed, having oversight, like testing the prisoners, make sure measuring the instructor. Too many of them there are just there for a paycheck. They just sit down in the office. They don't come out. They have bad attitudes. So I think that's part of that's again equipping people with gainful employment. That's part of crime. That's definitely part of crime deterrence. Parole. So in terms of parole, I mean, let me use the term now for the phenomenon I described earlier, the catch-20. It's called the innocent prisoner's dilemma, and so that's the dilemma of whether or not someone has been wrongfully convicted who has reached the end of their prison sentence minimum. Do you want to continue to stand on your innocence and thereby make it much more likely that your already unjust prison stay is going to be lengthened, or do you want to falsely admit guilt in order to slightly improve your chances at being paroled? But the downside of that, of course, is that if you're lucky enough to subsequently get the conviction overturned but don't have the indictment dismissed, then the prosecution could retry you and try to use those statements against you in the effort to try to reconvict. And it certainly would be problematic in terms of trying to receive compensation that could be used also. So, but I think in terms of people who've been rightfully convicted, it makes no sense that people who are model prisoners, I mean, for them to just be turned down for parole, referencing nature of the crime. I mean, if that's the name of the game, then let's eliminate every effort to rehabilitate, get rid of all the therapeutic programs and training. If we're just going to focus on what somebody did to get there, then there is no point to rehabilitation, and that's very demoralizing. So I think people who can demonstrate that they've been rehabilitated as measured by what programs they take and what their behavior is like, what the observations are of people in the prison. I think that model prisoners are people who have decent records. I mean, I don't think that you have to have a perfect record. I mean, I think it's overall the sum total of it. Certainly, having a lot of geriatric prisoners incarcerated makes no sense. I mean, I read a lot of parole decisions of people who are ambulating around like hunched over and in wheelchairs and you know, on dialysis and other really serious medical afflictions, and you read their parole decision, you would not live and remain at liberty without breaking the law. You know, societal safety is incompatible with your release. Those things again would be laughable if it wasn't so seriousness. Certainly, we need an overhaul in terms of compassionate release or medical parole. I personally knew some people who put in a medical parole application. So basically, when you've been determined to be terminally ill, you can put in effort to that application. And I saw some people die. They got their decision a couple of days after they passed. That's how slow and inefficient it was. And then I remember there was another person that by the time they ruled on it, he went home, he had like 2 days. So I don't, you know, it's just so vindictive, I don't really see where that furthers any legitimate penological interest, and I feel like that lowers us as a society. In terms of prison reform, do you want to break in? Or?
Yeah, no, I just want to, I don't want to interrupt you, but
Sure.
in terms of parole, I think it's important that people understand convicted serving a sentence. Could you tell me some of the obstacles that you face as opposed to a parolee, as an exoneree?
Yes.
If you can. Please.
Yeah, that's a great point. Yeah, I'm glad you broke in for that. Sure. In theory, right, the parole officer is there to help, right? Some of them are, some of them are not, right? But there is a centralized person there who is supposed to be orienting or making aware the person on parole of what community services are out there, recommending therapeutic programs, whether it's a drug program, alcohol program, violence program, whatever type of program, and help access public services. And there's a lot of prisoner reentry groups out there that help reintegrate. From programs to job placement to job employment. But for someone exonerated, there is no centralized person, and there are no nonprofit organizations that are really trying to reintegrate in a similar way. In fact, myself and a lot of other people who exonerated, we went to some of the prisoner reentry groups, and they were like, "But you're not on parole. You're not on probation." I'm like, "Yeah, I know. I was innocent. I wasn't supposed to be there. But I have a lot of the same difficulties in terms of housing and employment and social work and mental health needs, and the whole gamut of it." But again, they were adamant that they're not funded for that. They report their figures into the various entities that are giving them grants, and they can't reference me, even as a statistic. And then my argument then became, well, you're funded, right? The lights are on, all your programs are paid for, the salaries are covered. Is it going to, is it going to hurt you if one more person sits down and benefits? I don't get that. But they were not willing to bend on that. So that's the difficulty that I've faced as an exoneree. Another thing is that in the experience of doing time wrongfully is not the same thing as the experience of doing time rightfully. Being in suspense, like never knowing when your deal was going to be over. If I had been guilty and took a plea bargain, then I know what the minimum and what the maximum is. I knew a lot of people who they worked themselves into this place. Look, Jeff, I did what I did. It was wrong. I got caught. This is my penalty. So you know what? I'm not going to cry about it. I'm just going to do the best that I can and try to go home as quick as I can. I could never get to that place because I knew I didn't belong there from the beginning. So I think that the after effects, the symptoms are much more pronounced. I think that people, the society in general, they understand somebody who did something wrong and now is turned their life around, and not so much on the exoneration side. So that's not as well received, as ironic as that may sound. So changing gears and talking a little bit about prison reform. So here's my top 10 ideas. If you want further reading, or you can Google my name and then Google where it says Good Men Project and prison reform, and the whole article that I had previously published will come up. But let me just give you my shorthand of my top 10 ideas. For one would be, and these are in no particular order, separate youth from adults. So that's kind of obvious. I will not elaborate on that, except to say that if you're charged as an adult, even though if you're youthful, then they will house you in a maximum security prison. And for so many obvious reasons, I don't think that that's right. Now, they just passed to raise the age, so I do want to recognize that. I believe the age now is 21. Is 21? Is that the year?
I think so.
Yeah.
Maybe that at 18.
Yeah, one of the two. But they did raise it up from 16, so I was charged as an adult. But I still think, I mean, at 18 years old, though, you know, your mind's not fully developed yet. So it's not a good idea to house the two together, the two populations. Separate violent offenders from non-violent offenders. So you might be there for passing bad checks, and you know the guy next to you is there for assault in the first degree. You know, maybe he or she killed somebody. Now, in terms of separating violent offenders from non-violent offenders, two levels of that. Right? I consider there to be two levels of that. So, firstly, yes, according to what the crime is you're charged with. But then I also believe in a further subdivision in terms of how people choose to conduct themselves when they are incarcerated, regardless of the crime. You know, so I knew a lot of people that were there for violent crimes, but they were not violent. But you put them in an environment where they're around other people who are about a lot of violence, then the odds are much greater. Sooner or later, you're going to get involved in violence in order to defend yourself. Segregate vulnerable populations. So I think that people that are identified by security as likely victims, or they're easy to prey upon, or people who have mental health issues, I don't think that they should be in general population with everyone else to be taken advantage of. So I think they should be kept separate for safety purposes. Eliminate visitation deterrence. So, like a lot of times when my mother would come see me, they might wait 20 minutes, half hour, hour and a half. Sometimes it got up until 2.5 hours that she'd be sitting there in the visiting room, and you know, before I walked in the door, I mean, I had no idea that she was there. There's always, well, not always, but a lot of times there's hassle coming through the visiting processing and the verbal harassment, and I think that everything should be done to facilitate and encourage visitation rather than discouraging it. I'm against the Department of Corrections policy of they send people from the city to the facilities that are upstate, they send people from upstate to the facilities that are in the city, and the theory is you have to earn your way closer back down as good behavior. But since it's established that outside contact and family visitation and community support is a factor in successful crime-free reintegration, then you know I don't look at that as a privilege. I think that's a right, and I think that it hurts society overall. That's kind of like biting off the nose, spot the face. So I don't think that that's a good idea. Aggressively stop verbal abuse. Okay, so there's a general atmosphere. I mean, you know, you have no rights when you're there, and you're treated like less than a human being. And I'm against that. I believe that people are sent. The punishment is losing your freedom. It's not to be mistreated while there, and I think that that's not the right environment for rehabilitation. Often the people who are there for oversight, the sergeants, the captains, the lieutenants, the superintendents, they were once officers, and that, a lot of times that's even their buddies, so they're looking the other way. They're like hands off. And the courts are similarly very deferential. It's very hard to win any litigation in the outside court. Not impossible, but hard. Hard enough that it's perceived by many prisoners as a waste of time. The grievance system there is considered to be a joke because nothing ever happens, and if anything, you're going to make your problem worse because now you're going to be targeted for retaliation, not just by the officer you had a problem with, but any of their buddies as well. So I think aggressively stopping the verbal abuse, which could be done. In fact, it was always laughed about. The more outrageous some of the guards were and what they would say and do, the bigger the joke was. Upgrading medical care. So seemingly everything was treated in the prison, the solution, the cure for everything was take a couple Tylenols and, come back tomorrow. That was, that's inadequate, and then it might take a week, 2 weeks, or even several months before you can see a doctor. So it took me a couple of months. I had an injury. I was playing basketball and I caught the ball at a weird angle, so half of my finger, the pinky went to the other side. So I went right away to it's called sick call, and I saw the nurse, and it took them a couple of months to get me to see a doctor. And by then this thing had healed, and my pinky had healed incorrectly. The doctor had somehow lost track of his Hippocratic do no harm oath. As he told me, because I had some movement in the finger, he wasn't going to sign off and authorize that money be spent for me to go to the outside doctor and get a proper treatment. It has been found, I remember reading an article, I don't recall what state it was, but the doctors were not properly credentialed. It was a diploma mill, so that's another factor to be looked at. And a lot of times too, the medical staff, they kind of take on the attitude of some of the abusive guards, because again, when you have that environment where that's allowed to go on and nobody corrects it, it becomes the norm, it becomes the order of the day, and that spreads to some of the civilian staff. And I think that when it takes root, I mean, even people that originally start off with the idea of making a difference, they get worn down and they become part of that. And some people have told me, that it even became a safety issue because they need the backup and support of their co-workers, and they would not get that if they don't continue to look the other way. Improving the meal quality. So sometimes the food would be not fully cooked, while at other times it would be burned. I talked a little bit before about old food. I mean, there were some items that would appear on the serving line the course of the week, like vegetables would make 3 or 4 appearances before doing their final appearance Sunday night, their last incarnation in the soup, where it's a big vat and it's just a bunch of water and all the old stuff, and they just dump water on it, and that's soup, right? That's after it showed up 3 or 4 times already. I remember Sunday dinner, which we'll say tongue-in-cheek, was a couple of pieces of bologna, 1 piece of cheese, an old hot dog bun, a bag of chips that was mostly air, a fourth of a slice of peach, and the soup that nobody's touching. So that's Sunday dinner. Lunch might be 1 slice of pizza that's like a third of what a normal Sicilian slice would be. So portion control was a problem, in addition to undercooking, overcooking. So many items just had so much grease in it, it just was, you were healthier not to even eat. Maybe the last time, I already discussed college and the vocational curriculum, so I won't rehash. I believe in providing religious-based meal options. So in Greenhaven Prison, they have the kosher kitchen, for example, and certain items that that everything has to be kosher and stuff can't be eaten in the pans, and everything according to Judaism. And so that was provided in Greenhaven. So the Jewish prisoners got a hot meal, as should have been the case. But none of the other prisons were so equipped. And so really it was a cold meal all the time, always vegetables, always cold cuts. So yet when it was, I forgot what it was called, it might have been the Days of Cedar, but it was a lot of days, maybe 5 to 8. And on those days suddenly everybody could be given hot meals, but not all year round. So I do believe in freedom of expressing, practicing religion, and I don't think that offering religiously alternative meals is coddling your prisoners. I would argue that for all faiths, I mean, that should be done. If you're registered as one faith with this eating requirements, so we're gonna have that much less on the regular serving line, and it'll all work out. So maybe the last topic I'll cover before I close out, and this will be really quick. I'm going to discuss a little bit about capital punishment. So I was part of the successful warding off of capital punishment reinstatement efforts back in 2007, shortly after I was released. 3 different state troopers had been murdered in different cases, and so that was what the pro-death penalty proponents were utilizing to try to get the death penalty reinstated. So I was the moral counterweight to that, which is obviously the innocence argument and the obvious risk of potentially executing somebody innocent. I think a lot about my own case, and if I'd been 18 rather than 16, and possibly I could have got the death penalty. I mean, the factors that make a capital case a capital one rather than non-capital were present, which committed the outrage, a brutal crime, and then sex offense along with the murder. Those are all standard factors that make a case a capital rather than non-capital case. My appeals ran out in 2001, and I wasn't exonerated, until 2006, so I would not have been around to be exonerated. So you're putting people in a really impossible position, which is already impossible to begin with. It's such a hard thing to prove innocence, because remember, the burden of proof isn't on the government anymore. It's on the defendant of scant resources and their advocates and attorneys, often of scant time and resources. It's already hard enough battle as is against too often skeptical courts, and to put a clock and to risk death is unconscionable to me. But that's not the only thing to take into account. I've met a lot of the crime victim family, the murder victim's family, and a lot of them are opposed to capital punishment because they feel like they relive the crime all the time because of the increased publicity around the appeals. And a lot of them feel like even when a death penalty is carried out, that they don't have any closure. They don't feel any better. There's no more They don't feel the justice that they were promised eludes them. From 1995 till 2004, in New York, we had the death penalty system. $200 million was spent on it, and nobody was executed. And I think that the money could have went better at social programs and crime prevention. I think that killing people who kill in order to show that killing is wrong is kind of a circular argument. I think that it lowers society down to the level of the murderer. I think it's below human dignity. And the other problem with, a couple of other problems I'd be remiss if I didn't hit. Certainly the racial aspect to that. The race of the victim matters. So, people. So if a minority is a person who is killed, then most of the time the death penalty is not sought in that situation, whereas the opposite is true, so it's sending a bad message in terms of value of lives, and certainly the race of the defendant also is a factor. The death penalty is a little bit arbitrary, so it depends on the personal politics of the district attorney in that jurisdiction at that time, whether they believe in it or don't believe in it, as to whether it will even be sought or not. So there is kind of an arbitrariness in that respect. Death row, I can't imagine being, just the way death row is. Being, 23 hours a day rather than 24. They don't have access to programs. There's no group recreation, and just sitting there waiting to be killed, and the whole system becomes unworkable. And imagine doing that, 10 years, 15 years, 20 years, 25 years. That's all happened. I can't imagine that, you can't have one without the other. So I believe that the whole system as a whole, when it comes to that, is really unworkable. I think in terms of non-statutory reforms, in terms of preventing wrongful convictions, tunnel vision is a big factor. So that's the tendency, once a conclusion is formed, to then ignore all evidence to the contrary, and just look for evidence that will support a conclusion, and to either ignore, minimize, or explain away evidence to the contrary in such a way that is absurd and defies really just logic and common sense. there's a tension in the criminal justice system between, this is on the judicial level. So first of all, the courts are not good at catching and correcting wrongful convictions. The average length of wrongful imprisonment is 14.5 years. And it's typical that most people have had their appeals exhausted way before they were exonerated. So the courts are not good at catching and correcting them, the wrongful convictions. The tension in the justice system is finality of conviction versus accuracy. So the idea that, look, you had your day in court, enough already. Are we going to? When do we get to stop going through this? You know, you can't. So there's that mentality, and with the idea that, you know, you can't keep retrying the case forever, which in a way is true. But there's that concept versus accuracy, which, what good is the final conclusion if the final conclusion is wrong? So I think anytime it's warranted, the case should be looked at, should be reviewed. But that tension in the justice system, along with a very closely related tension, which is proceduralism versus substantive justice. So I think that substantive justice is always what should carry the day, and not the procedure, not the technicalities. It should not have mattered that I was 4 days late. Forget the court clerk clause, that. Forget that. Just if I was legitimately 4 days late, if I was legitimately 5 months late, if I was 6 months late, if I was years late, so what? Don't you think the argument itself should be looked at and evaluated and ruled on the merits, and that really determine how things go? I mean, I do. So those things are factors, and, you know, I think that the judges are getting more open-minded to considering innocence claims. I think that's why the level of exonerations are going up. A few years ago, the New York Times had a study where they said that in 25% of the exonerations, that there was some level of police or prosecutorial cooperation. So that's another big factor. So I want to recognize that. But at the same time, let's not kid ourselves. Okay, that's 25%. So that means 75% of the time, that's not what's happening. Okay, so I don't believe that there's a few bad apples from the prosecutors or from the police, because if that's the case, we wouldn't have such a huge problem. Okay, it's not a few bad apples. It's a heck of a lot more than that. Okay, but there are some ethical there, and I consider that a big part of the problem are the police and prosecutors who look the other way, who allow the misconduct and everything to become the order of the day, and allows it to take root, and that sets the stage for wrongful convictions. Hey, thanks for listening.
So I want to open it up to questions from the class again. Thank you so much for speaking. I tell you, Jeffrey mentioned a number of great points. We posted articles about, especially Alabama's rush to sort of get to the death penalty for a number of inmates. That tunnel vision of which you spoke, that sort of cognitive dissonance, right? So just looking one way, if anyone read Robert Cialdini, if you haven't, it's a great book, Influence, seminal work. So when you bet on a horse, you keep on rooting for the horse no matter what. Once they had a vested interest in the outcome, the prosecution, right? It's hard to both do justice, which is what a prosecutor's job is to do. We heard from the two prosecutors who sat here. Do justice, but also it's an adversarial system where both sides want to win. So it's hard. It's sort of like an alter ego or a schizophrenic sort of system of justice that we sit in. When a prosecutor is fraught with these two ideas, actual innocence, yes, could exist, but at the end of the day, a prosecutor's job is not necessarily, in theory, it's supposed to be to do justice and to do those things, but not necessarily guided by that prosecutor's discretion, right? We heard from those two prosecutors who were here. They have to take orders from higher up. Doesn't matter in let's just say for taping, in X county that you know, you might not have done it. If you are charged with DWI, you're going to jail, at least in X county, right? And think about that. That doesn't really have to do with whether that person's innocent. It just has to do with whether they've been charged, which is, you know, from a week ago. I want to highlight one thing in particular, and a lot of people, they sort of, will sit in these classes, and I can't tell you how much I appreciate you coming to really put some meat on the bones of the criminal mind, because we see a lot of this system is not necessarily working as it was in our textbooks. I do want, if we have a few minutes, talk about some of the sex offender, treatment programs.
Yes.
Like, for those who are audio, air quotes, treatment programs, where these sex offenders have to essentially admit guilt and admit liability, undergo polygraph examinations. The Supreme Court just recently struck down the idea that these individuals, although they serve their time, although they have certain limitations, can't go on the internet, can't associate, freedom of association, which is from Facebook to Lord knows what other social groups or Snapchats or whatever it is out there. But I want to highlight one thing. I think Jeffrey did mention it, but I really wouldn't do credit to this class if we didn't highlight a parolee who is guilty and who's been convicted and processed through the system, received more benefits, received more support, received more supervision, whether it was penal or simply corrective supervision, than someone who is exonerated and in fact not guilty. And just so we understand that, the burden has not only shifted, but this person has been found not guilty by virtue of innocence. When they talk about a miscarriage of justice, there is no greater miscarriage of justice than an exoneration, aside from maybe someone who's exonerated simply after death.
Do you know what the formal explanation is for that disparity?
I was about to ask Jeffrey.
There is no formal explanation for it. The quasi-rationalization for not doing anything is, well, this isn't a large enough population, so we're not getting we wouldn't get a lot of bang for the buck. But that argument's kind of hollow to me. Really quickly, to back up Corey's point, there's a 3 to 7 year gap between point of release and when somebody receives compensation, so there is no safety net in the middle, and I just want to point that out. And the other thing that doesn't make any sense to me, well, a couple of things actually now that I think of it, but when someone's been exonerated, there's a finding of innocence, like you mentioned, it doesn't make sense that the case has to be retried again. I mean, guilt, innocence is litigated in the Court of Claims in New York State, whether someone's going to be compensated under New York State law, and sometimes even within the context of the 1983 federal civil rights lawsuits, guilt, innocence is sometimes at issue, and to make somebody reprove it again after it's already been done, that's unjust to me. And then what makes no sense either, and I'm going to yield back the floor, is that it took less than a year. It took less than a year to railroad me through the court system. But, it's 3 to 7 years it's this multi-year, long, slow, drawn-out process to get compensated. Why? Is it because that it's a citizen that's the defendant in one instance and it's the government in the next? I don't see why there is this big slowdown. It makes no sense to me. And to me, each day without the compensation, and being released with nothing, it adds insult to injury.
I want to elaborate. So 1983 is not just a year; it's the section of the section of the United States Code 42, United States Code, Section 1983, that allows you to seek compensation from a state actor or constitutional violation. And here he was seized his Fourth Amendment right. Fifth Amendment right to due process. A number of things were violated. I actually want to give the floor back to you because, look, what Jeffrey mentions, if you look at the Central Park 5, who recently just had a very large settlement, no acknowledgement of wrongdoing, but a very large settlement, I think it was 40 million?
Yeah, as amongst 50 million as amongst 5 defendants. Remember, it took 10 years to get that.
I want you, if it's all right with you, to just tell us, you see his press, the picture of the press that he showed earlier. Can you tell us about that moment to the time that you received compensation?
Yeah, and that's, well, the picture really that encapsulates that is here, my difficulty, and then, my release. Yeah, it was very difficult. I didn't have stability of housing, so I bounced from place to place, and at one point I was on my way to the homeless shelter. Thank God Mercy College stepped in and upped the ante on their scholarship. They allowed me to stay on campus, otherwise I would have been there in the homeless shelter. I was never able to find gainful employment because, first of all, the technology was new, and all the employers seemed to want somebody who could hit the ground running rather than being patient and give me some on-the-job training for a couple of weeks, even a month, and either I can hack it or I can't, but that wasn't their vibe. One person said to me, one business owner, look man, I'd like to hire you, but first of all, I don't know what the reaction of my other employees is going to be. Are people going to be protesting outside and not patronize my, my business? So there was some of that. So I did have a job as a weekly columnist, but it was a weekly column. So I got like $250 an article, which is really good money for one article, but they only wanted one a week. And I had no other way of making money other than doing presentations, but that's like being an actor in a way, in the sense that if, you get a role, you get paid, and when you don't, you don't. So thank God for Human Development Services of Westchester. By coincidence, just by virtue of mental health diagnosis, I happened to fit their criteria of clients that they served, that they rented an apartment for, and I had to give them 30% of whatever I made in the course of a month, even if that was nothing. So once that happened, I finally had some stability of housing, but that took like a year and a half, but a lot of people, exonerees, end up homeless or in shelters. I was not above doing some things I'm ashamed of, but I'm going to share with you anyway, because this is all, awareness. So, I wasn't above hiding in the bathroom when I went on the subway. I'm not on the subway, but on the train, so that my ticket doesn't get punched, so I could use that again to travel. I used to carry a backpack around, and I would have like bowls of cereal in there, and I would have tuna fish. I couldn't eat anything out. I couldn't really even afford the train. I was resorting to what I just told you. So it was a very, very difficult situation for me. It was particularly hard. About like 25% of the exoneree population, they were originally arrested, wrongfully convicted while still youth. So I had never had my own apartment. I never had a driver's license. I never had to go shopping for myself. I never lived alone. And you add all that to the difference in technology, and then not knowing people, and not having, really not being tuned in at all in terms of the culture and what's in, and not having a social network. I mean, it was many times I felt really depressed. Not even so much of what had happened, but in terms of the poor quality of life as it was. I wanted to do things, and still want to do things that most people my age don't want to do. I still want to throw a ball around, and let's go in the bumper cars, and I want to play sports and try out different new things. But who are the people to do that with? Think about it, being dropped in the planet, like a different planet. But who are my peers? Who are the people to do that to? Well, they did that a long time ago, and they're married and they have kids, and they don't really seem to be committed to balance, a balanced life. Of doing so. It's not them, but then younger, but then I don't look like them either, and so to them I'm almost like reminiscent of like a parental figure who couldn't possibly be any fun. So very, very lonely, a very, very lonely existence, and has been well documented. If you go to YouTube and type in Deskovic Foundation, and my YouTube channel comes up, and a lot of videos there, but for this one I'm talking about, there was a really poignant New York Times video, which illustrated with the difficulty, in my first year. So it was like from the fire. It was like from the frying pan. Well, the fire to the frying pan, or however the saying goes. I know one thing. It was a far cry from what I used to daydream about while I was in the prison. I used to think that I was going to live in a neighborhood that I wanted. I thought all these things I used to see on television I was going to go and do. It kind of went without saying that I'd be able to obtain gainful employment, doing something meaningful at the same level that I would have been had my life not been disrupted And I never stopped and thought that none of those things are really how it goes. It's a very difficult life trying to put one's life back together again. So, you have a question for Stephen?
Yeah, so you were put in when you were 16, you spent 16 years in there. You spent half your life. When you got out, I guess my question is, what were some skills or mentalities, life lessons that you learned in there that you still that made you who you are today? Yeah,
that's a really great question. I only got that one time before. So I was arrested when I was 16, as we went over before. Yeah, here we go again, workshop. So and then I turned 17 by the time the trial rolled around, and I lost. So I was inside from 17 to 32. So in terms of life lessons that I learned while I was in there, that I apply now, that were positive, I would have to say just not giving up. I mean, once I set a goal, you know, just keep going at it. I mean, have a plan, execute the plan, move towards the goal, but be flexible enough to continue to move to it in a way that you hadn't thought of or perceived originally. So that's one thing. I really value education and reading, and that really came alive in me while I was in prison. From 1998 forward, I read like 3 or 4 nonfiction books a day, including self-help books, so I definitely believe in that. And I used to read and use myself as a dagger. So whatever I thought made some sense, then I went with, and whatever I didn't, I just ignored that and keep going. So those 2 things, definitely appreciating the small things. So like I enjoy just being outside in the nighttime. I like to feel the sun on my face, or just the breeze, or to be in control of the electric, to turn the listen. If the power would go out, God help you, the power went out in your cell. All right, you might be like that without electric for like 3 days. Okay, so just having control of that, freedom of movement, just able to socialize and to, whatever goals that you want. I mean, you can go for, you can achieve them. You don't have the barriers. I mean, I wanted to keep going in my college, and I could not because it was taken from me. I didn't have all these educational opportunities. So, just valuing those things. Putting a focal point on self-improvement and developing different sides of the self. I mean, I love to learn and expand my mind, even in an informal basis. So those are all things that I gathered from the inside. And there's a general idea, like the humanization is not an option. Just from being mistreated to the extreme. I feel like I have a strong sense of justice and not to go past her. I'll tell you a quick story, real fast, I promise, Corey. So, give me a second here to gather myself and let me use the water to pretend I'm not gathering myself, okay? So I was sitting in, the setting is this, so I'm in federal court where this deposition is being held, right, of the actual perpetrator. So I'm prosecuting my lawsuit against Peekskill, against Putnam County. This is great, right? Because I'm going to tell you now, because their defense to that point, before they dropped it and settled, this is Peekskill, their defense in a nutshell was that Deskovic is guilty and therefore we did nothing wrong, right? That was their strategy, right? Even though the DNA never matched me, it ultimately matched the actual perpetrator who killed somebody else, who confessed to the crime, right? Forget all that, I'm guilty, right? In fact, one of the detectives got so exasperated by my lawyer, he just blurted out, right? You can imagine this in your deposition, right? You'd love to have this happen. The guy there was a colloquy right here. Well, first he blurted out, he said, look, the only false confession in this case was given by Stephen Cunningham, right? The actual perpetrator, right? Yeah, so do you know the DNA didn't match my client? Yes. Do you know that the DNA did match another person? Yes. Do you know that that person confessed? Yes. Do you have an explanation as to how his DNA got, how this 29-year-old's DNA got inside a 15-year-old victim? No. Do you still say my client's guilty? Yes. So just utterly destroyed him right there. So that's their theory, that's the setting, right? And so our strategy is, since the way my false confession mirrors the police theory of how the crime happened, why not refute that by proving how the crime did happen, which is, the actual perpetrator. So in that context, we're in the federal court just deposing him, the empty courtroom except for the stenographer and everything, right? And so as we wrap up for the morning session, we're about to go for lunch, and I'm going to gather myself and pretend that I'm not and drink some more water. And so my lawyer, he starts like nudging me like conspiratorially, like, we're going to get something really good now. And he says, he says to me, that SOB isn't going to get lunch. Isn't that funny? And he starts chuckling, right? And what did you say? And he repeats it again. Isn't that great? Isn't that great? And he's chuckling. I'm like, no, it's not great. What do you care? Look what he did. He killed 2 people, and he was quiet. He was happy to let you sit in prison for his crime and not say anything. And I said, listen, he eats. You're going to make sure he eats. You're going to ask him that when he comes back from there, or I'm going to ask him. And then I'm going to take whatever other steps I can. And so we come back from lunch, and he's given extra water, and then he's asked, well, did you eat? Did you eat lunch? Were you given lunch? And he confirmed that he had. So I feel like as a human being, that was one of my finest moments. Dehumanization is not an option. Putting that in practice, no matter what the circumstances are. We can't go below certain things, and I feel like I try to carry that out. That was clearly a lesson from the prison.
Do you see a difference in gender in a wrongful conviction?
Yeah, there's many more men who are exonerated than women, and one of the reasons for that, I'm glad we're going there in this discussion, is that most of the innocence movement is DNA centric, and meaning most of the organizations will only take on a case if there is DNA, which is again 5 to 12%, and so that's typical items that can be tested for DNA would include semen, saliva, blood, hair, nails, sweat, and most of the time that's left by a male, not a female. So many women are not eligible for representation in many of the innocence organizations. One of the hot topics now is shaken baby syndrome, and so basically what that is in a nutshell, it's like a default diagnosis. So if they can't determine any reason why a baby suddenly died, right, then they resort to saying it's shaken baby, and then the only inquiry at that point is who was last with the child. So, and then that's who's charged. And so a lot of women have been wrongfully convicted in cases like that. That's just now starting to come out. So there's definitely women exonerees. I know a bunch of them, but I have no doubt there's many more still on the inside than on the outside, because it's an underserved population. There is one innocence organization specifically donated to, not donated, but dedicated to that. But it's not. That's nowhere near enough. In fact, my organization, we have one woman client. But
we talked about like medical care and how it took months to fix the baby.
Yeah.
Did you have counseling?
And it was never fixed either, by the way. Only to get to the doctor, have them decline. Yeah.
Was there like counseling, and like what did you do if like there was a major injury?
Well, you said counseling. You're asking if there's mental health counseling?
Yeah.
All right. So there's mental health services provided there, but here's the thing. I mean, the most difficult stretch for me was when my appeals were over. Because prior to that, I just thought I was doing a year or two until the next appeal, the next legal proceeding, which I was sure I was going to win, because I'm innocent, and I naively thought that the court system got better the higher up you went. So when my appeals were exhausted, that was the time period that was really the most difficult for me. And so at times I did try to see mental health experts, but Basically, they told me after the second time, well, first of all, I felt like I was just a number. There wasn't really there really wasn't much empathy there. But then they also said that their caseload was just so serious, so large, and that they had no time to deal with people other than people who had hallucinations and were delusional or psychotic. So they felt they didn't have time even. So that's on the counseling part of it. But that's only half of your question. What's the other portion of your
Well,
question?
I was just like, what if there was like a major injury, like after a fight or something, where did those prisoners go?
Well, they would initially, there was a hospital on the prison grounds. You'd go there and then you would see the nurse. There was always a nursing attendant on duty. And from there, if there was more than what they could deal with, then they would bring you to the outside hospital. You know, the other thing, pointing that out is getting into women's issues. So there's one of our clients who is a woman. It came out in the course of that one of the really silly rules, I think, in the Florida Department of Corrections is that if a prisoner is staying in an outside hospital for treatment, then the only people who would be allowed to come and visit would be family members. So if someone is originally from another state, and they have extended family or they have friends or other supporters, those people would not be allowed to visit in the hospital, only the family. So that's another angle to it. Certainly the usage of leg irons and handcuffs on people who are in hospitals, that remains controversial. I know there's been times where women have had legs shackled together while giving birth. That's been a big issue. Yeah, I mean, and why is like we in 2000, what year it is, 2017. But I mean, some of these things to need to even go to court, the need to try to even pursue legislation. I mean, really, just to know not to do that. I mean, I don't understand a lot of things by the Department of Corrections. But is there any other part of your question that?
Just another question.
No, follow up. Let's do it. That's what we're here for.
If this happened in present day, like 2017,
Yeah.
do you think you would have the same outcome as you had, or with the use of social media, do you think you'd have a support group behind?
Okay. All right. So a few different things to say on that. So firstly, let me just say this: that I think that DNA lulls us into a false sense of security. We think that it can't happen now. But if the technology is only available in 5 to 12% of the cases, so then how can it help in those 88? Right? So it can happen now as easily as before in terms of the DNA can't save it. The other big problem is that the systemic deficiencies that I laid out that have led to the wrongful convictions of the past that are turning into exonerations now, some of them. Those deficiencies are largely unaddressed by legislation and better voluntary implementation by law enforcement. So those cracks are still there for people to fall in. That having been said, I think that the general public is more aware of DNA now. So I think in my case, since I had been excluded pre-trial, I think that probably the DNA evidence would have been bigger. But then the problem is that I still have the terrible lawyer, right? And so he's not really pushing that or making that the centerpiece of his defense. So, would I still be wrongfully convicted? Probably. I mean, I guess I have a better shot that I might win despite him. But there is a definite danger now. I think that social media is big in terms of exonerations. I mean, could that happen pre-trial? Yeah, theoretically, but as a practical matter, not really, because the reason, there's always, there has to be standards, right? You're not going to just parrot innocence claims. There has to be based on some educated guess, review of the legal documents, some analysis. But pre-trial, where are the documents to do that analysis? There is no trial transcript because there hasn't been a trial yet. So it's hard to determine that ahead of time on a large scale like that. So I think that social media would be somewhat limited value. And I think that problem is often compounded by defense lawyers in the sense that the prosecutor and the police are not shy of making statements on cases and talking about evidence, and, you know, but a lot of lawyers, they just have no comment. And I believe it's important in defending a client, to defend them in the court of public opinion as much as in the actual court. So you can even out the media, try to even out the stories that are out there, so that the environment doesn't get set in which, you know, a wrongful conviction is more likely to occur. Prejudicial pretrial publicity, I mean, that can infect the jury pool. It can, most of the time, it's driven by the prosecutors, but at times they can be caught up in it. The judge can certainly be swayed. That's certainly a factor in terms of how the judge rules at different junctures in a trial. It can certainly affect a sentence. I know as a defendant, at the middle of a lot of prejudicial pretrial or guilt presumptive oriented media coverage, that's a very, very scary feeling. I mean, that feels like an out of control feeling, like it's you against the world. And yeah, so I mean, those are my thoughts on your question.
Was there cameras in the court? Because you have pictures in the courtroom, and what do you feel about cameras in the court?
I'm totally in favor of cameras in the court, video cameras, still shots. They didn't have video cameras in the court. I would like to see, you know, trials. I'd like to see cameras in the court, period, transmitting it. I think also, I think that's far superior just to sit transcripts alone. I think probably having both. So I believe in transparency, and I think that the sunlight, the disinfectant, the analogies that go are all true. I think that the judges' rulings would be more fair, and I think that some of the more outrageous tactics by the prosecutor wouldn't be done quite as much. I think he would balance it out. So I'm all for it. I'd love to see it.
So a lot of us are in the federal counseling program or general master's in psychology program.
Mm-hmm.
And there's a term that we use, like when we're talking about trauma, something that you went through, post-traumatic stress disorder.
Yes.
There's a term that isn't really shined upon as much, which is post-traumatic growth, which I think you're a shining example of. What is it about your experience that you were able to turn, you know, your hypervigilance and symptoms that you were struggling with to now being the leader of a foundation and fighting for other people's rights?
Yeah, I think that so a few things true at once. I mean, in general, people have been through traumatic experiences, as you said. If it doesn't destroy you, then you can rise up a level above it and find some inner peace. And that, well, I don't like talking about that. In general, okay, not as to me, you can make your own conclusion. But that lends itself to having some wisdom and stuff like that. So, now what enables that to be a reality is my decision, and a lot of this decision from a lot of people, not to be angry, not to be bitter. You know, and a lot of things go into that. So I think that if you're angry or bitter, then you can't live a meaningful life and get the most out of life and enjoy as much as you can and be angry or bitter. So that was one thing. And then another thing, maybe less noble, was I realized that if I was angry and bitter, it's not like I'd be adversely affecting any of the people that did this to me. It might be a different story then. But another thing is that I feel like I lost so much. Why would I lose more? And I'm not going to let people totally, you know, beat me. You know, so that's, you know, my success and my growth and the good that I do and whatever heights I can, you know, achieve or try. I mean, that's my revenge. Trying to fix and make the system more accurate. That's some of the best revenge I can have. So all those lines of reasoning at the same time, with the release valve being I take the energy that I would feel and I channel into the advocacy work that I do. So those things enable me to have that inner peace within me, you know, which is what allows the other dynamics to, allows rest of the dynamics to take place. I mean, I spent a lot of time in my own mind. It's not so much a physical living in a prison as it is a mental living, and so reflecting on, you know, the world around me and myself, and, you know, I feel like I do more of that than a lot of regular people. I think that that's part and parcel of what you're saying, post-traumatic growth. So I think that's a factor. I mean, it's a factor also, and then maybe just developing more patience. I mean, just in trying to communicate with people, I mean, I realize that it's hard for people to grasp everything, and so, you know, maybe if there's no frame of reference for them to understand, it's hard for me to have a discussion about what I experienced while I was on trial and while in the prison and my difficulties afterwards. It's hard to discuss that if I'm not talking to someone who's going to do something similar. So I know they don't have a frame of reference. So again, I think that lends to some, that lends to more of a patience, and I found just in people changing opinions that, I mean, I feel like I realized that if people had access to more information, then perhaps their views would change, at least in some instances, and so that's part of the patience, and I feel like that's a part of it as well, what we're talking about.
You spoke about how your brother and how it negatively affected him. Can you tell us maybe a bit about how you being released affected him as well?
How what
You
affected
being released affected him as well? If it
Yeah, sure. So, some other aspects of how he was negatively impacted, then I'll get to the other side of your question. So, I know at one point he says that he turned to drugs and alcohol in order to deal with that, but he eventually cleaned himself up in terms of that, so I was happy about that part of it. But in terms of how my being released impacted him, well, I mean, in a lot of ways, he's still like searching for the lost years or lost youth. So when I interact with him, he seems frozen in time. Like he's still talking to me like he's like 13 and I'm 16, and then the youthful thing. And on one hand, it's nostalgic, but that lasts for like 5 minutes. And like, look, we're adults now. Calm down, relax. I don't want all this excitement. I have PTSD. I need things to be nice and calm. Just relax. Yeah, okay, and right back to the same way. So he seems stuck in that type of humor. And I do feel he's searching for himself in a way. Like I remember one time, a couple of times actually, he asked me, hey, do you want to move? Let's move back to Peekskill. I'm like, where everything happened. I'm like, no, you don't. What you're looking for, you're not going to find there. Like nobody that we knew, none of our friends, none of that life that we once lived, that's not going to be what's there. That city is not the same. It's different people and everything's different. So there's that part of it, and just adjusting to having somebody in his life again that wasn't there before. You know, but I mean, not everything's good with that either. In the sense that every now and then, I mean, the fact that I receive some compensation becomes a point of contention. You know, he comes up with these wild schemes of how to get rich and how he wants to be partners with this, that, and the third, except that he doesn't have his part of it, and you know, you don't know what you're doing, but you think that you do, you know, and I'm not willing to like squander and lose, and I know what it is not to have, and I'm never going back there, God willing, so I'm not doing all of that, but that has led to tension and being upset and even an element of jealousy with that at times. I think another thing though too is that overall he really didn't make too much of his life, to be perfectly blunt. You know, and you know, I'm doing the best that I can, and I have some achievements, and I think that I'm recognized for that, or the attitude and demeanor people have, or how they talk about that on one hand and not on the other. You know, that's led to some, you know, difficult times with him. But then the way that we view the world is different. I mean, to hear him tell it, this presentation tonight, okay, was stupid. Why are you talking about that? Why are you involved in that? What are you getting at that? Why don't you try to make some money? You're never going to put all this stuff behind you because you're always talking about it. You're always involved in it. So the larger sense of things passes him by. You know, I don't like anything illegal. I've had more than my share of problems with the law without doing anything wrong, let alone if I was to put myself in harm's way by doing something wrong. But look, it's not that serious, man. Come on, it's not that. So just relax. And no, I'm not relaxing, man. I don't want anything around me that's not, you know, correct. You know, so there's that. We're like a world apart now. You know, so that's the full picture on that.
No further questions? Thank our guests one more time.
Defense
Thank you
rests.
so much.
Defense rests.
Thank you so much for coming out here. Thank you.
Can I take a picture next?
Yeah, I will take a picture. Just one second. Just give me 1 second.